The charges in the Proud Boys trial are count 1, seditious conspiracy, which is what Ryan's reporting on. Count 2, conspiracy to obstruct an official proceeding. Count 3, conspiracy to obstruct an official proceeding and aiding and abetting. Count 4, conspiracy to prevent an officer from discharging any duties. Count 5, obstruction of law enforcement during civil disorder and aiding and abetting. Counts 6 and 7, destruction of government property and aiding and abetting. Counts 8 and 9, assaulting, resisting, or impeding certain officers. And count 10 is robbery of personal property of the United States. Glenn, the floor is yours. I just wanted to broaden this out in terms of all that this jury is having to deliberate over.
Yeah, Nicole, I'm glad we have Ryan as the eyes and ears on what's going on down there. And let me, now I can be accused of seeing the justice glass as half full, but let's talk about the fact that the jury is suggesting they're having some trouble unanimously deciding the lead charge, the seditious conspiracy charge. So first of all, what happens when a jury sends a hang note out saying, hey, judge, we've deliberated, we've taken some votes, we're having a difficult time unanimously deciding these issues. The judge at first will say, thank you very much, go back and keep working. This is a 4-month trial. You all have only been deliberating 4 days. We are nowhere near hung jury territory. But if they send out another note and they say, look, we've tried, we are deadlocked, that's when the judge will give what's called an Allen charge. That's an anti-deadlock instruction. It's been around since the late 1800s. And it's an instruction that tells the jury, look, you should decide this case one way or another if you can do so consistent with your personal view of the evidence. And it's kind of a gentle prodding by the court to try to nudge them in the direction of a verdict rather than a hung jury and a mistrial. But the judge can't overstep, because there's a lot of case law that says, you can't coerce a verdict out of a jury. So gone are the days that we sequester juries and say you're not coming out until you reach a verdict. That doesn't fly anymore. But here's the thing. Let's assume, Nicole, that they end up hanging on the lead charge, seditious conspiracy, but convicting on all of those other counts that you just put up on the screen. That will still expose these defendants to decades in prison, and it will also give the prosecutors the opportunity to retry the lead charge, the seditious conspiracy charge. It's almost a win-win. People will view it as a loss if they don't win a conviction on the lead charge. But tactically speaking, it won't necessarily be a loss, because then they can leverage a retrial on the lead charge in favor of telling some of these defendants, look, you may now want to talk with us post-verdict to not only reduce your sentence that you're facing on all the other convictions, but to avoid a retrial on the lead charge.